We'd like to welcome you all to our webinar this afternoon or this morning, depending on where you are. My name is Patricia Julianell, and I am NACY's Director of State Projects and Legal Affairs. And I'm joined by Barbara Duffield. Barbara, are you available to introduce yourself?
I am here. I am NACY's Director of Policy and Programs.
Thanks. Next slide, please. Before we get started, we wanted to give you just a little bit of a background on NACY. We're not sure if everyone who signed up for the webinar today is familiar with the National Association for the Education of Homeless Children and Youth. We are a national membership organization dedicated to educational excellence for children and youth experiencing homelessness. And we do work from early childhood up through higher education. We do work for youth experiencing homelessness through our local youth task forces. We have higher education networks in approximately 20 states around the country, and a very active early childhood committee working on child care, Head Start, and access to other pre-K services. We do a lot of technical assistance around the country, as well as policy advocacy with Congress and state legislatures. And in all of our work, we work in partnership with young people through our scholarship program, as well as in our policy and other programmatic work. Just a quick bit of housekeeping for our webinar today. You should have a control panel visible on your screen. Depending on the version of GoToTraining that you're using, that control panel may be a little bit large and it may be obscuring your view of the screen. If that's the case, if you click on the little orange arrow that you can see in your control panel, clicking on that orange arrow actually will make your control panel get smaller, and you can hide it. And then if you want to see your control panel again, you can click on that orange arrow again, and your control panel will get large. We are recording this webinar, and we will be archiving it on our website so that colleagues and others can take a look at it later. And we also want to let you know that we will not be taking questions or comments over the telephone or orally over your computer microphone, but we will be taking questions and comments via the chat box. So again, on the right hand of your screen in the control panel, you should see a chat box or a questions pane. You're welcome to type questions in there at any time throughout the presentation. We encourage you to share your questions and comments with us. And at the end of the presentation, we'll take a look at that chat box and we'll be able to address your comments and questions then.
And this is Barbara. I'll just say too that given that this is very new, not every question will we have answers for. The guidance doesn't address every question, but we are every bit as interested as you are in finding out answers. So even if we can't provide an immediate answer, we will do our very best to find out afterwards and get back to you and get back to the group too. So I just wanted to put that out there too. We are in some very early stages of some new policies here.
Absolutely. Very much of this and how this is going to be implemented really will be seen in the fall and particularly next year. But we're going to give you the best information that we can about the guidance that came out just about a week and a half ago or so. So moving on, we want to give you just a little bit of context for the guidance that we'll be talking about today and some background. The first thing we want to let you know is where you can find the actual documents that we'll be referencing throughout our webinar today. We have right there the actual links where you can get the documents and download them onto your computer. If you don't have a copy of this PowerPoint, if you look under the Materials tab in your control panel, the PowerPoint presentation is there and you can download it right now or at any time during the presentation. We will be talking about a Dear Colleague letter having to do with the effective dates of the Title I provisions relating to students in foster care. We'll also be talking specifically about the non-regulatory guidance, and you can also see the link there for a stakeholder engagement letter that the Department of Education also released. A little bit of statutory context for the guidance that we are going to be speaking about today. Of course, this is the guidance related to Title I and its provisions for children in foster care. So the Every Student Succeeds Act, or ESSA, did include significant amendments to Title I Part A, and those amendments are designed to provide school stability and immediate enrollment in school to children in foster care. Now those amendments, again, are part of Title I Part A, so they are not a part of the McKinney-Vento Act. We've gotten a lot of questions and a bit of confusion about that, and so we just want to make sure it's clear. The McKinney-Vento Act also was reauthorized as part of ESSA, but it's actually in a completely different title. It's Title IX, Part A of ESSA. And of course, those of you who work with the McKinney-Vento Act know that it is a separate statute from Title I, Part A. So even though the two programs work very closely together, they are separate. And the guidance that we're going to talk about today really has to do with amendments to Title I, Part A, and is not related directly to the McKinney-Vento Act. Just to make sure, again, that we're just being very clear about the two different programs, ESSA, part of its amendments to the McKinney-Vento Act did remove the phrase awaiting foster care placement from the definition of homeless. That change goes into effect on December 10th, 2016 in all but 3 states. And if anyone on the webinar is from Arkansas, Delaware, or Nevada, in your state, that actually goes into effect December 10th, 2017. Again, this is all part of really the effort to make sure that all children in foster care receive protections related to their school stability and their ability to enroll in school, but that those protections are under Title I, Part A, and really separating that and that population from McKinney-Vento and services to children and youth experiencing homelessness. Before we talk about the guidance for children in foster care, we thought it was important to go over what the statute says. This is what Congress passed. It's the language that Congress approved last December, and it's really ESSA that gives the Department of Education the opportunity to issue guidance on the education for children in foster care. So this is really the foundation for all of the implementation that will be taking place around the country. And this is really the touchstone for what school districts and state departments of education will be doing for children and youth in foster care. So just to go over what those amendments are and really where we're starting from and what our touchstone will be, ESSA amended both the state plan section and the local plan section of Title I, Part A in regard to students in foster care. So let's start with the state Title I plan amendments. Now under ESSA, state Title I plans must describe the steps the SEA or state educational agency will take to ensure collaboration with the state child welfare agency. So again, just from the very first clause of the sentence, it is a collaborative approach and a collaborative responsibility. Those two agencies working together to ensure the educational stability of children in foster care. That educational stability must include a few different assurances. The first one is that foster youth can remain in their school of origin unless a determination is made that it is not in their best interest to remain in the school of origin. If there is a determination that it's not in their best interest to stay in the school of origin, then that student must be immediately enrolled in a new school. In addition, changes to the state Title I plan, every SEA, state educational agency, must designate a point of contact for child welfare agencies who will oversee implementation of the SEA responsibility. So again, within the Title I program, there needs to be a point of contact so that child welfare agencies know who they are working with and who will be overseeing these new amendments. That point of contact may not be the same person as the McKinney-Vento State Coordinator. So again, as I said a couple of slides ago, really looking at separating those two programs, separating those responsibilities so that all children in care are receiving protections through this Title I program, and that McKinney-Vento programs really are focusing on children and youth in homeless situations. Now looking at the ESSA amendments to the local Title I plans as it pertains to children and youth in foster care, local Title I plans also must contain an assurance that the LEA will collaborate with the state or local child welfare agency. So again, just as we saw at the state level, these local requirements really are looking at collaborative approaches, working together, shared responsibilities and shared approaches to these issues. So first of all, the LEA must designate a point of contact for foster care issues if the corresponding child welfare agency notifies the LEA in writing that it has designated a point of contact for the LEA. So again, you can really see the emphasis on collaboration and on corresponding duties and corresponding responsibilities. Ideally, there will be someone at the child welfare agency that the LEA knows who their contact is there, and vice versa at the LEA. So that point of contact at the local level is required if the corresponding child welfare agency has a point of contact for school districts. Now, ESSA does not specify whether the McKinney-Vento liaison can be the point of contact. So we saw on the previous slide that at the state level, the state point of contact cannot be the McKinney-Vento coordinator. At the local level, there is not that same specificity saying that the local liaison cannot be the foster care point of contact. However, as LEAs consider who to designate as their foster care point of contact, it's very important to make sure that they're paying attention to the new ESSA amendment to the McKinney-Vento Act that requires that liaisons are able to carry out their duties described in the law. So for those of you on the webinar who are familiar with the McKinney-Vento Act, you know that there is a section of the Act that contains, I believe it's now up to 9 specific duties that the liaison must be in charge of and must be implementing. Before designating that liaison as the foster care point of contact, the LEA needs to make a determination that that foster care, that liaison can carry out all of the McKinney-Vento duties under the law, and then also looking at what the foster care population is in the school district, and will that person actually be able to carry out the duties of both positions adequately. Next slide, the last section here on local Title I plans. Within 1 year of enactment, so enactment was December 10th, 2015, so within 1 year of enactment it would be December 10th, 2016, LEAs must develop and implement procedures, again, this is in collaboration with their local child welfare agencies, to look at how transportation to the school of origin for youth in foster care will be provided, arranged, and funded. Those procedures must ensure that foster youth who need transportation to the school of origin promptly receive it in a cost-effective manner. And ESSA specifically calls out the child welfare agency's authority to use child welfare funding to pay for this transportation. Under Title IV-E of the Social Security Act, foster care maintenance payments and administrative funds are available to be used to pay for school of origin transportation for youth in care. And ESSA specifically references those funds as a way to fund transportation to the school of origin for students in foster care. In addition, those transportation procedures that the LEA and Child Welfare Agency are implementing together must ensure that if there are additional costs incurred in providing transportation to the school of origin, that LEAs will pay for those additional costs in 3 situations. First, if they are reimbursed by the Child Welfare Agency. Second, if the LEA agrees to pay the costs. Or third, if the LEA and the Child Welfare Agency agree to share the cost. So those are the provisions that we have in ESSA. That is the statutory language that really provides the foundation and the grounding for how child welfare agencies and LEAs will be working together over the coming school years to implement these provisions. Now we want to take you to the guidance and the Dear Colleague letters that came out from the Department of Education. So just for some procedural clarification, as I said before, the law is the law that was passed by Congress and signed into law by President Obama in December of 2015. Guidance and Dear Colleague letters don't come from Congress, they come from an administrative agency. In this case, they're coming from the Department of Education and the Department of Health and Human Services jointly. So what guidance and Dear Colleague letters do is they provide the interpretation of the Department of Ed and the Department of Health and Human Services of the legal language that we just saw on the previous slides. So guidance, again, they're not laws, they're not regulations, so they're not legally binding, but they do represent an interpretation that the agency has come to through their looking at the law over the past few months. Guidance can change as laws are implemented, as different realities are brought to bear, and as different interpretations of the statute become prevalent. We also want to make sure that we're distinguishing this guidance and these Dear Colleague letters from the proposed regulations that also were published a few weeks ago. So on May 31st, 2016, the Department of Education published proposed regulations You can get information on those regulations on our website, and you've got the link there on your PowerPoint. We'll talk a little bit later about the process for the public to provide comment on those regulations. The public has until August 1st, so just a little bit less than a month now to submit comments on those regulations. The Department of Education is required to consider those comments and is very likely to make some adjustments to their regulations based on those comments. So today we're not focusing on the regulations. We'll talk briefly about those later, but we're really focusing on the guidance and the Dear Colleague letters that were issued. So let's start with the Dear Colleague letter, and then we'll talk about the guidance. The Dear Colleague letter we want to focus on is one about effective dates. And again, the link to this letter was on a slide that we showed you just a few slides ago, so you can download that and look at the exact language of the letter. The Dear Colleague letter actually changes the effective dates from what we were anticipating for many of the ESSA provisions related to children in foster care. So last December, Congress passed the Consolidated Appropriations Act. That's the act that actually appropriated funds to Title I and to other governmental programs. That Consolidated Appropriations Act said that states and local school districts were required to implement these ESSA amendments to Title I for the 2017-2018 school year. There is one piece of ESSA that I mentioned on a previous slide, the transportation procedures, that had a specific earlier date of December 10th, 2016, but the other provisions were supposed to go into effect for the 2017-18 school year under that Consolidated Appropriations Act. However, in terms of effective dates, ESSA, the statute, does give the Department of Education a little bit of leeway looking at how to roll out the implementation of ESSA in order to ensure what's called an orderly transition. And what the Department of Ed essentially has done is it looked at the removal of awaiting foster care placement from the McKinney-Vento Act. It looked at the implementation date for the transportation procedures, which is also December 10th, 2016. And the Department of Ed basically said that they're going to use their orderly transition authority to change the effective dates of some of the other foster care provisions. And the way they're doing this is grant awards that will be going out for fiscal year 2016 for Title I will include a condition. Every SEA's grant award will include a condition requiring the states to go ahead and implement some of these provisions effective for this upcoming 16-17 school year. Now let's get to the next slide and we'll get into the specifics of what's going into effect when. So what the Dear Colleague letter does is it says that the following provisions will take effect on December 10th, 2016. So it's trying to pull together a few different pieces and make them all go into effect on December 10th. We already know that we have awaiting foster care placement removed from the McKinney-Vento Act on December 10th, 2016. We know that we've got the transportation procedures going into effect on December 10th, 2016 for all children in foster care. And now, pursuant to the Dear Colleague letter, what we also have going into effect on December 10th, 2016 are the requirement that state Title I plans describe the steps the SEA will take to ensure collaboration with the child welfare agency. So again, not wanting that collaboration to wait another year, let's get that started as of December 10th, 2016, if not sooner. And having those assurances for educational stability, the ability to remain in the school of origin if in their best interest, or be immediately enrolled in a new school if not in their best interest. So that's going into effect in December. The other piece going into effect in December is the requirement that SEAs designate that foster care point of contact, which we talked about, again, who shall not be the McKinney-Vento State Coordinator. That person should be in place in states by December 10th, 2016. In addition to those state requirements, there's also the requirement that LEAs collaborate with child welfare agencies to develop and implement those transportation procedures. Again, ESSA makes that provision go into effect on December 10th, 2016, and the Dear Colleague letter just confirms that that does go into effect on 2016. The Dear Colleague letter does not appear to change the effective dates for those local points of contact. It's a little bit confusing, but as you read through the Dear Colleague letter and the guidance, the Dear Colleague letter specifically cites the provisions that go into effect earlier. And that section that requires LEAs to designate a foster care point of contact if child welfare agencies have done the same. That does not appear to be one of the sections that the Department of Ed is putting into effect in December. The guidance also does not appear to do that. What the guidance does say is it suggests that LEAs designate those points of contact in an expedited manner, and that's on page 21 of the guidance if you want to download that and take a look at it. But it does not appear to change the effective date officially to December 10th, 2016. That means that it appears that legally the effective date for those local points of contact will continue to be the 27-18 school year. Some school districts might want to do that ahead of time to facilitate implementation, but that is not a requirement. That hopefully will give districts a little bit more time to do that analysis that I was speaking about earlier, which is if they're considering making the McKinney-Vento liaison also serve as the foster care point of contact, since the McKinney-Vento amendments go into effect on October 1st of 2016, that gives school districts some time to implement the new McKinney-Vento amendments, look at how that implementation is going, and determine whether the McKinney-Vento liaison realistically is going to be able to implement all those new ESSA amendments to McKinney-Vento, and also at the same time be working on the foster care provisions as well. So that hopefully will facilitate that transition.
And this is Barbara. I'll just say too that I think, you know, while the department has authority from ESSA to proceed in orderly, you know, to do an orderly transition, and is using that to make provisions on FY 2016 state SEA grants, I don't think that they could have the same authority to impose conditions on local fiscal year 2016 local Title I grants because of that going through the state. So I would just, you know, a sort of conjecture on my part, but guess that they don't have that authority because it's a local grant, and also just because, you know, there needs to be some time for the child welfare agency to designate its own point of contact, because the requirement, the trigger, if you will, for an LEA point of contact is the designation and the providing in writing that the child welfare agency designate a contact and tell the LEA about it. That obviously would be tough to do by December 10th. So a little bit of conjecture on my part, but I think that those are two important rationales to keep in mind too for the point of contact.
Absolutely.
We're going to switch now, and Patricia, I'm assuming this is where my section starts in, to talk about the non-regulatory guidance and what it actually says. So again, it is just a reminder that it's non-binding, it doesn't create or impose no new legal requirements. And that's why it's so important when we're talking about the guidance to first start with the statute. That's what's actually required. So this, as Patricia said, is the department's interpretation of the statute and is not to create or impose new legal requirements. What it does do is it references Fostering Connections, the child welfare counterpart of 2008. And this is important because in any piece of legislation that really is dependent on good collaboration, it's important for both agencies to understand what each side is mandated to do. So it references Fostering Connection and summarizes those provisions around educational stability, again, including that the case plan ensures educational stability, that the placement of each child in foster care takes into account the proximity of the placement to the child's school, and the coordination with school districts to ensure that each child in foster care can remain in their school of origin if it's in his or her best interest. So again, important in any collaborative effort to know what the child mandate, what those are as well. We do have in the guidance, and this also is in the proposed regulations, a definition of child in foster care for the first time in federal education law. This is the same definition that is used by the Department of Health and Human Services to define foster care for child welfare agencies. So there is an exact match between the definition of a child in foster care for school purposes and for child welfare agencies. I'm not going to read the entire definition to you here, but you can see what it is. This is, again, a definition that will be familiar to child welfare agencies, but maybe less familiar to school district personnel. So it's an important piece to consider as well. And again, I won't read over all of it, but it essentially is the exact same definition that child welfare agencies use. My guess is that because this is the same definition, it is in the guidance, it is in the proposed regulations, this is very likely, I would guess that we would be likely to see this in the final regs as well. In terms of the SCA responsibilities, the guidance repeats the statutory language. It also states that the state education agency should coordinate with the state child welfare agency to develop and disseminate uniform guidelines for educational stability. And this really, if there's sort of one overarching theme of this guidance, is both the need for collaboration and also the importance of state-level guidelines and policies. And we'll come back to that again and again. It's why we, for this webinar, decided to open this webinar just to SCA personnel, because not only did the state provisions go in sooner than everyone anticipated, but also there's a great deal of emphasis in the guidelines for states coming up with their procedures collaboratively. And again, the guidance repeats the designation of the state point of contact by December 10th. In terms of the general LEA responsibilities, as they are touched upon in the guidance, again, there's the collaboration responsibilities at the local level. With respect to preschool, the guidance states that the educational stability provisions apply to preschool children if an LEA offers a public preschool education. It does not define public preschool education. It simply says if an LEA offers a public preschool education, then the educational stability provisions of ESSA would apply. They also give an extra emphasis to this need for capacity. So the guidance states that it's essential that the designated points of contact have sufficient capacity and necessary resources to fulfill their duties. I will point out too, though, that while the ESSA statutory language very clearly says that the state point of contact is responsible for implementing the educational stability provisions, there are actually no legal duties in ESSA for the local point of contact. The guidance suggests some things, but they actually don't have legal responsibilities in the same way that McKinney-Vento liaisons do. In terms of the school of origin definition suggested by the guidance, they have defined school of origin as a school in which the child is enrolled at the time of placement in foster care, and if the child's foster placement changed, that the school of origin would then be the school in which the child was enrolled at the time of the placement change. And again, the guidance permits children to stay in the school of origin for their entire time in foster care. So it is similar to, but certainly not exactly the same as, the definition of school of origin for children and youth who under McKinney-Vento. Obviously the conditions of foster care are different, but this is the guidance, the definition of school of origin suggested by the Department of Education. Looking at best interest determinations, the guidance, and we have a direct quote here, encourages state education agencies to work with state child welfare agencies to establish guidelines that would be used by both school districts in schools in coordination with child welfare agencies to guide this decision-making process. They repeat student-centered factors that should be taken into account when deciding whether a child in foster care should stay in their school of origin or move to a new school, and encourage the involvement of the school, the child welfare agency, student, foster parents, biological parents, and educational decision makers. Again, unlike students who are in homeless situations, there are many more people, many more adults typically involved in the life of a child who's in foster care, and the guidance really emphasizes the need to involve all of those parties in best interest decision-making processes. In terms of the timeline on best interest decisions, the department's guidance says that these decisions about best interest should be made as quickly as possible to prevent any educational discontinuity, and also that the student should remain in the school of origin while that best interest decision is made to the extent feasible and appropriate. It does not define those terms, but again says that they should remain in the school of origin during best interest to the extent feasible and appropriate. It goes on to say that if there's a disagreement about which school is in the best interest of the child to attend, the agency should make every effort to reach an agreement about the appropriate, but if there's a disagreement regarding school placement for a child in foster care, the child welfare agency should be considered the final decision, the final decision maker entity making the best interest determination unless state law or policy dictates otherwise. And we've underlined this because it appears again and again in the guidance that these are suggestions from the Department of Education on how things should go, but states have the discretion to develop their own policies. So there, the department is recommending that the Child Welfare Agency be the final decision maker in best interest determinations, but very specifically acknowledges that state law or policy might dictate something else. So that's something really, I think, really critical to take into consideration as these new policies are being developed, particularly around disputes. Other dispute items, again, we encourage SEAs and LAs to collaborate to develop a dispute resolution process at the local level, and that to the extent feasible and appropriate, that the child remains in his or her school of origin while disputes are being resolved. So again, the guidance is really looking to the state education agency to develop a dispute resolution process that would be helpful at the local level too. With respect to transportation, again, as Patricia stated, the statute, the transportation obligations are at the local level, local procedures to be developed collaboratively with the Child Welfare Agency, and those local procedures spelling out who pays if there are additional costs under 3 specific circumstances. The guidance goes ahead and encourages the state education agency to include guidelines for how additional costs for transportation will be funded, and establish a mechanism or policy for LEAs to resolve interagency disputes related to transportation costs. So again, this is an important opportunity to think about what would an appropriate dispute resolution policy look like for transportation, for best interest, that serves children well, but also makes sure that agencies are appropriately held responsible for the parts that they are responsible for. And again, the guidance repeats the statutory language about the school district responsibility on transportation. One thing it does a little in terms of interpreting the statute is, again, the statute says that the LEA and the Child Welfare Agency collaboratively develop procedures to make sure that transportation to the school of origin is provided, and if there are additional costs, LEAs would pay under 3 specific conditions, that they're reimbursed, that they agree, or they agree to split. The guidance defines additional costs as the difference between what an LEA otherwise would spend to transport a student to his or her assigned school and the cost of transporting a child in foster care to his or her school of origin. So I think this is the first time we've seen an attempt to sort of spell out what additional costs actually would be and how a district and child welfare agencies might calculate that. In terms of funding, again, the guidance encourages child welfare agencies to continue to work with the school districts in exploring the range of options for providing and funding transportation to maintain the child in his or her school of origin. And again, states the shared agency responsibility, and that the school district and the local child welfare agency should make every possible effort to reach agreement. So this is part of the reason why NACI and the American Association of School Administrators, the superintendents, put out a guide on the questions that would be necessary for school districts and child welfare agencies to consider together in developing these procedures. We put that guide out in April. We'll be updating it shortly to reflect some of this guidance, but it is really important that those conversations be guided by important questions. And I'll just say too that in developing that guide, we relied heavily on state and local coordinators who had struggled through this issue of educational stability and specifically transportation procedures and payment. So I would really encourage you to take a look at that guide. It's on our ESSA page. If you go under the ESSA page, you'll see children in foster care, and you'll see a link to that guide there. Because again, this is going to take some time. December 10th isn't too far away, and there are some very important considerations that need to be made collectively for those procedures to be good procedures. In terms of transportation funding, the guidance restates allowable funds, state and local funds typically available for transportation, 4E funds for children who are eligible for 4E foster care maintenance payments, and Title I funds, but states that the homeless set-aside funds under Title I may not be used for transportation for children and youth in foster care. Again, December 10th, the homeless will not include any children in foster care, and very specifically, the department has stated that the Title I set-aside fund is for children and youth who are covered under McKinney-Vento. With respect to transportation disputes, the department recognizes, though, that there may be disputes, and those of you who have worked in McKinney-Vento for a while or with the waiting foster care placement may find that to be kind of a strange statement, because we know that disputes happen all the time even between school districts, and certainly they will occur between school districts and child welfare agencies. Again, an important reason for having a state-level dispute process to deal with all of that. But the department's guidance urges that the transportation procedures include dispute provisions, again, encourages states to develop a uniform state dispute process, and that LEAs would provide the transportation while payment disputes are resolved. So here too is another opportunity for the state education agency to begin to think about what a dispute process would look like, and to make sure that it is constructed in such a way that agencies can't sort of use it, if you will, to ensure that one agency is on the hook. We did see with the waiting foster care placement in some places that the easiest way to get, for example, a school to pay for transportation would be to simply invoke the dispute process, and then transportation would be provided. So now is an opportunity with this SCA dispute process to really rethink what that would look like between agencies and how it could be constructed in a way to avoid those sorts of situations. With respect to immediate enrollment, the guidance states that enrollment should be as soon as possible, even in the absence of documents normally required, that the enrolling school must contact the prior school to obtain records, and that SCAs and LEAs should take steps to revise policies that are barriers to enrollment and attendance. So again, very similar policies to what we see for children and youth who are homeless in the McKinney-Vento Act. And there's, again, here we pulled out specifically some of the additional emphases on collaboration. So encouraging child welfare agencies to revisit how they're coordinating. It's been a long, 2008 was the passage of the Fostering Connections Act, so it's been quite a while. So now is a time, not just for the SCA, but also for the state and local child welfare agents to revisit how they're coordinating to meet their own requirements. And again, really encouraging child welfare agencies to notify school districts when students enter foster care or when there are changes in foster care placements. These educational stability provisions are so critical, and yet schools need to know when children are put in care or when they are changing placements in order for children to actually benefit from them. So that will be another critical element of the state and local collaboration that will be necessary to make sure that children benefit from these provisions. So you have the language in the pages there, or the question numbers there. And next slide again, really looking at strong partnerships, consistent collaborations, encouraging cross-training and interagency working groups. So those are very good, excellent suggestions for making sure that people are speaking the same language and on the same page about what each agency is required to do and how they can best work together to make sure that the goals of the legislation are met. And with that, we want to take a pause here for implementation discussion. We want to close out by just returning to the proposed rules that are hanging out there under the public comment period. But we want to take a pause here before we finish up with those proposed rules and just have some question and answer. Some of your things you may be already working on, implementation discussion around best interest, disputes, point of contact, potential concerns or considerations at this stage.
Well, Barbara, I have been able to answer most of the questions in writing in the chat box, but just to say a few things out loud so that everyone can hear. The legal references for anything that we talked about from the guidance or the Dear Colleague letters are on the slides in parentheses at the end. As far as the actual ESSA language, on our website, on the NACCE website, and the actual citation there is in the chat box if you want to take a look at it. But We've got a red line of Title I that shows the actual statutory language for these changes, as well as a summary of the changes. So you can take a look at our website and really get all of the exact ESSA language and citations there if you'd like to. I also wanted to clarify, I think we may have used the word may in kind of a legal sense that might have been a little bit confusing. So the separation of the foster care contact and the McKinney-Vento coordinator at the state level is a required separation. That is not at the discretion of states. Those two people must be different people at the state level. At the local level is where it is discretionary, and that's where LEAs will need to look at the capacity of the liaison to meet their duties under the law for all students experiencing homelessness in that district. So I wanted to make sure that that was clear, because I think I may have been a little bit unclear on that. And this is another area where I think maybe we lacked a little bit of clarity. The Dear Colleague letter and the guidance, they do not change the dates on which Title I plans are due. So whenever the Department of Education tells states that your Title I plans need to be submitted by a certain date, or if you have waiver plans that need to be submitted, those dates aren't changing at all. What is changing is the implementation date for a couple of the foster care provisions, and those are the ones that we talked about, primarily related to the state's assurances that they're working with child welfare agencies and that they are providing school stability and immediate enrollment to children and youth in foster care. So those really will help make sure that when awaiting foster care placement comes out of McKinney-Vento, that there aren't any students who fall through the cracks, so that as of December 10th of this year, there really will be a complete transition of children in any stage in foster care out of the McKinney-Vento Act under Title I Part A, and again, that will really be much better because it will cover all kids in care and not just that small subset of students who may have met the definition of awaiting foster care placement. I think those are the questions that came in that I just want to make sure I answered out loud. There was a comment that maybe can start some discussion, and we encourage you to put any comments into the chat box, but there was a comment shared and a question. It would be great for others to chime in on this. Have other states been successful in developing an agreement with state DHS? And this individual says, I contacted our state DHS last week, and they had just become aware of this for some reason. And so looking at kind of how to get some kind of collaborative agreement or some kind of MOU together, if any of you have been successful at that in your states, how have you gotten people to the table together, and how has that collaborative work been going? So if anybody wants to chime in on that in the chat box, please do. There's also a question that just came in, Barbara, that I think would be good for you to address because it was from one of your slides. And the question is, how long must transportation be provided during payment disputes? According to the guidance, it seems that a child welfare agency could dispute every transportation payment, and the LEA would have to pay for that cost.
Well, again, I think, and Patricia helped me out here too, but I mean, there isn't a timeline on disputes. The importance of the dispute process and of the SCA creating a sensible one cannot be overstated for those exact reasons. Under McKinney-Vento, states have to have a dispute process. They typically enumerate the number of days available for each party to bring forth a complaint and what those steps are. That will be very, very important here. Again, this is an SCA law, so while the guidance states that these need to be collaborative procedures, I think it's really critical for the SCA to take the lead in drafting a uniform dispute process that does not, that is not open-ended. That does put some very finite parameters around when disputes, how long they last, and who does what when. Again, I think that just sort of underscores that importance, and it will validate that concern because, again, we did see some of those same issues pop up under awaiting foster care placement with McKinney-Vento.
Thanks, Barbara. Right now, I don't think we have any other questions at the moment, so if you want to go ahead and then we can come back and do more questions again in a couple minutes.
Sure. So again, now we want to go back to the proposed regulations. These, unlike the guidance, these would be binding. These would have the force of law. They were published on May 31st. And again, they'll be finalized after the public comment period, which ends August 1st. There are a number of pieces where those proposed regulations do touch on foster care and homelessness, transportation, achievement and graduation data, and state plan consolidation. The proposed regulation, transportation for students in foster care, is very much at odds with the statute, and it is not really, it's not consistent with the guidance either. We have it here on the slide. The state education agency will ensure that an LEA receiving Title I will provide children in foster care transportation as necessary to and from the school of origin, consistent with the local procedures, even if the LEA and local child welfare agency do not agree on which agency or agencies pay any additional costs incurred to provide such transportation. So the statute is very clear that if there are additional costs the LEA pays under certain circumstances, this proposed regulation really undermines the collaboration envisioned by the statute. There would not be collaboration, there would simply be child welfare agency not agreeing to pay costs in order for schools to pay. So there's been a good deal of negative publicity for this regulation, articles in Politico, articles in EdWeek about this. There were hearings in the House Education Committee. This issue came up at least 4 times with great concern being expressed. It came up in the Senate committee last week, and Senator Franken, who is a champion for children in foster care, told the U.S. Secretary of Education, John King, that he did not like this proposed regulation and that he was offering his comments that the department should go with the guidance, which again encourages states to develop their dispute process and to go with their guidance over the regulation. So there's been a great deal of negative publicity around this and concern from legislators about this proposed rule. Public comments will be essential. They are due August 1st. They can be submitted via the web at this link there. We have created a template to make it easier for people to submit comments. It's very important that comments be individualized to the greatest extent possible, so you can take some template language, but I encourage liaisons or other people to look at that and to make their voices heard, because again, the department does have to consider it. And we also think it's important to share these comments with members of Congress as well, because any legislative effort as big as the reauthorization of ESSA is going to be evaluated and changed and looked at for years to come. So it's important to go on record at the get-go. So we would very much encourage you to do that. And we've also provided just some general resources here. Again, our website is listed first. We have a extensive ESSA page, which will become even bigger, and on that page you will find the foster care section that has the transportation guide developed by NACI and AASA that we'll be revising too, but I think is still a very good resource as those procedures are being developed.
Thanks, Barbara. Just in case people are having any trouble navigating the chat box, I wanted to read out loud a few responses that we got into that question about, have people found success with working collaboratively with their state child welfare agencies? We did get a comment in from New Hampshire that New Hampshire recently started a group of HHS and Department of Education people, both at the state agency and local level, to start the conversation. So they're getting started in New Hampshire. We also got a comment in from Virginia that Virginia developed some joint guidance in 2010 based on fostering connections through a collaborative between education and social service staff, and the links to look at those resources and the guidance from Virginia are in the chat box. And we also heard from Delaware that Delaware has had a collaborative group including LEAs, child welfare, the Delaware Department of Education, judges, child advocates, et cetera, for years. They have meetings in large groups quarterly and also in smaller working groups almost monthly. And there's a link to an MOU out of Delaware if you'd like. Of course, that'll have to be updated now based on the changes to the McKinney-Vento Act. And Delaware is one of those states where awaiting foster care placement actually stays in McKinney-Vento for 1 additional year. So Delaware is a bit unique in that regard. Beth is wondering if those folks from New Hampshire, Virginia, Delaware, if you'd be willing to be contacted by her. So go ahead, if you don't mind, Pat and Linda and Jennifer, just let us know yes or no in the chat box, and we can see if we can make those connections. And if you, I'm happy to make those connections offline as long as you're all willing to do that. We also just got a response in from Texas with some links to their foster care and student success resource guides. So you can take a look at those in the chat box as well.
And this is Barbara. I make Patricia do chat box duty because I get very distracted and with all the text going by, so I actually am not looking at the chat box. But I'm very curious. We poured through this guidance, and parts of it are clear, parts of it are less clear, but I would just be curious to know the general reactions if you feel this guidance is helpful in your implementation works, if you have concerns about it. We are continuing to talk to the department. We are continuing to talk to Congress. So your reactions to this in terms of both what you anticipate happening, what you've seen happen, we really want to know those two. It's very helpful for our work, both in our policy advocacy, but also in our implementation work too. We are very invested in making these policies work for kids in foster care as well as kids who are experiencing homelessness who don't have the protection or the resources of the child welfare system. So we're in it for the long haul, and we know what we know when you tell us what we know. So really would encourage you, even if it's not by the chat box, if you want to shoot us an email afterwards, really very, very interested in your perspective.
Absolutely, and our email addresses are on the very first slide if you've been able to download the presentation. Most of you have our email addresses already, but if you don't, you can find those on the first slide, and I'll go ahead and type them into the chat box right now as well, just so that you have those handy. Well, Barbara, I think we've answered all of the questions. There has been a question about whether people can see the correspondence that occurred in the chat box, and probably the easiest way to do that is if you want to see what's in the chat box, just drop me an email and I'll send you a Word version of it. I do see some people who are kind of typing in maybe some concerns or some questions, so we do encourage you to just keep on doing that. The chat box is open, and you're welcome to do that for the next few minutes, as well as sending us an email. But I don't think we have any more questions that we need to address, Barbara.
Great. I know many people, I've gotten certainly a number of questions, people wondering when the McKinney-Vento guidance is going to be out. We have been told that the McKinney-Vento guidance, we might see it as soon as in a couple weeks. We are extremely likely to see it at least by August, but we might see it as soon as in a couple weeks too. So that will be very, I think, helpful too, because we have an expedited timeline with McKinney-Vento going into effect on October 1st. And our National Center for Homeless Education, our wonderful partners at the Department of Ed TA Center will, I'm sure, be doing a lot of updating of their materials as well.
I don't see any more comments coming in, Barbara, so I think we're ready to close out, and thank everyone for joining us today.
Thank you, everybody. Have a great rest of your day and a great rest of your week.